So your lemon law case was successful. Congratulations. But what do you think will happen next? The purchaser of a lemon has two options under California lemon law. Vehicle buyback and vehicle replacement are the two different options. Please continue to watch to learn more. Hello and welcome back to our channel, Alpha Law Firm. In today's video, we'll discuss how to win a lemon law case and what you should do afterward. Before we begin, please subscribe to the channel and switch on notifications so that you will be notified of each new upload. You may have purchased a lemon if your new car has required numerous trips to the dealership for repairs. The lemon legislation needs documentation of either a recurring repair of the same problem or that the car has been in the shop for repairs an exceptionally high number of times, regardless of whatever state you live in. While it's an aggravating situation, you can protect yourself and your wallet by following these 5 tips. The first thing you should do is contact a qualified lemon law attorney. Lemon law disputes can be difficult to navigate, needing a thorough understanding of not only the laws governing defective automobiles, but also the obligations that the procedure places on you, the manufacturer, and the repair facility. By contacting an experienced lemon law attorney as quickly as possible, you can protect your investment in your vehicle as well as your safety and the protection of your loved ones. Your attorney can guarantee that you have gathered all of the necessary documentation and that your claim is filed within the statutory deadline. Furthermore, your attorney may advise you on the advantages and disadvantages of taking a refund or replacement, as well as appropriately evaluate the expenses you paid while trying to get your vehicle repaired. Your lawyer can also help you figure out whether there are any other state or federal laws that apply to your case and could affect the amount of compensation you are entitled to. If you possess a lemon car, speak with an attorney to learn what you are entitled to. You have the option of requesting a refund or a new car if you file a lemon law claim on your vehicle. You can only be charged a small cost for the miles you drove before the first repair that qualified you for lemon law coverage, regardless of which option you choose. To find out how the cost is determined, look up your state's lemon law. If you request a refund, it will usually cover sales tax, registration, and other expenses paid at the time of purchase, as well as incidental fees incurred as a result of the lemon car, such as towing or rental car fees. You should not be compelled to pay sales tax on any other taxes related to registering a replacement vehicle if you want one. In addition, the manufacturer should reimburse you for expenses spent as a result of having a lemon car, such as towing and rental car charges. You should also be aware of what a reasonable number of repair attempts entails and who can provide them. In general, California law states that 4 tries to remedy a fault in your car are sufficient and that more attempts are unlikely to yield a different result. 2 efforts may be sufficient if the problem is likely to result in serious bodily injury or death. You must check that the repair shop attempting to rectify the fault is an approved repair facility that has been certified to undertake the repairs by the vehicle's manufacturer. You can get the repairs done at the dealership where you bought or leased the automobile, or you can go to another authorized repair facility. Failure to employ an approved repair facility will not only count against the number of repair attempts required by the lemon law, but it will also void the warranty. Check to see that you've provided all of the required information. When dealing with a lemon automobile, you and your repair service must keep track of certain details. A service report or invoice from your repair shop must include the following information: the vehicle's mileage, the dates on which the car was serviced, the customer's grievances. This is the section of the service report that repair businesses frequently alter or leave out. While your complaints are being entered into the computer, keep an eye on the monitor to ensure that they are all being logged accurately and completely. Repairs that have been attempted. In addition, the invoice must include the following information: the vehicle's make, model, and year, The VIN, which is normally found on the inside of the driver's door, is a unique identification number for each vehicle. The service writer's name, as well as the name of the mechanic or technician that attempted the repairs. Keep a record of anything that pertains to your lemon law case. Because of the way the law is structured, you must demonstrate that reasonable attempts to correct the fault on your car were unsuccessful. The records from the repair shop and the manufacturer describing your complaints, the work that was advised and executed, and the contents of your contacts with these companies are the most crucial proof you have that these attempts were made. You should also keep the following types of information as evidence for your case: a list of all repair attempts, as well as the length of time your car was out of commission during each attempt. Written, dated listings of the issues you've requested that your repair company investigate, as well as images or videos of the issues. You should provide the repair business with these lists, images, and videos, but you should also save copies for yourself. A list of the problems you've noticed, including any unusual sounds or odors you've noticed while driving your car. Any technical service bulletins or TSBs issued by the manufacturer for your car's make and model. Dealerships have access to TSBs so that their service departments are aware of alleged remedies for known problems. California's lemon legislation protects consumers by allowing them to receive a refund for the cost of their vehicle or a replacement vehicle of equal value from the manufacturer. The best option for you will be determined by your unique needs and circumstances, but there are a few points to keep in mind when choosing between a replacement and a refund. Keep watching to learn more about these concerns, and don't forget to use the thumbs up button. If you have any questions, feel free to ask them in the comments section below. In either situation, the purchaser of the damaged car is entitled to a variety of vehicle-related damages. You have the option of choosing between buyback and replacement. Although it appears to be a straightforward operation, it can be a little more difficult in practice. Alpha Law's lemon law attorneys are well versed in these laws and can assist you with the procedure. When we say vehicle buyback, here's what you may expect if you win a lemon law case and choose car buyback. If the customer opts for vehicle buyback, the manufacturer is required by law to completely reimburse the buyer minus a calculated cash value for the usage of the car before it's developing issues. As a result, for car buybacks, the manufacturer is required to cover the purchase price. This usually entails a refund of the down payment as well as any monthly payments. In addition, the manufacturer would have to compensate you for taxes on sales or use, fees for registration and licenses, other government fees, accidental losses such as repair, towing, rental, transportation costs. However, California law reduces the total amount the manufacturer must reimburse you by a dollar figure for your use and benefit of the car before it first exhibits technical faults. The mileage offset is the term for this. Well, don't worry if this appears to be difficult. Lemon law attorneys at Alpha Law can assist you with every aspect of your lemon law case. Let's talk about vehicle replacement now. Vehicle replacement is less popular than vehicle buyback. Part of this is due to the lemon law regulation, which requires the buyer to compensate the manufacturer for the use of the old car before the occurrence of the problems. The replacement vehicle must include all of the same warranties as a brand new car. Furthermore, the replacement vehicle should be nearly comparable to the previous vehicle. In addition to the replacement vehicle, the manufacturer is liable for sales or use tax, license fees, registration fees, other official fees, incidental damages such as repair, towing, transportation, and rental costs. If we can prove that the violations of the lemon law were willful, the court can impose a civil penalty of up to 2 times the actual damages, regardless of whether replacement or buyback is chosen. You might be wondering how long it will take for you to receive your funds. According to California law, If a car is judged to be a lemon, the buyer must be given a cure as soon as possible. That is, the manufacturer must reimburse the customer for the car or replace it, as well as compensate for any other damages as soon as possible. But what is promptness? If you don't pay on time, you may face further penalties. Because each situation is unique, speak with one of our experienced lemon law lawyers at Alpha Law to guarantee you recover your damages as soon as possible. That's it for today's video. Remember that this is not legal advice and does not constitute attorney-client relationship. Call now to learn more at 323-51-LEMON. Don't forget to hit the subscribe button and do not forget to turn on the notifications to be notified of every upload. This is Alpha Law Firm, and we will see you on our next video.